All right. So when last we spoke, I said that the last lecture would be your last one, and that didn't turn out to be true. But this one actually should be. So we'll see. We talked 15:1 before this, so if you didn't listen to that one, I would certainly do that. That talks about classifications of people in terms of reasonable and unreasonable classifications, and then also like scrutiny tests for laws. And the scrutiny tests really are there to see whether a law is discriminatory against a certain group of people, and if it is, should it be? And I know that sounds kind of silly because, like, no, of course it shouldn't be. But there are times in which the government does decide, or the courts do decide, that the government has a compelling interest to, or a business that's being sued has a compelling interest to have a policy or a law the way that they do, and that the discriminatory part of it is fine because it accomplishes other goals. It doesn't happen often, but that does sometimes happen. Okay. It's interesting though too because the strict scrutiny test. I'm just going to head back to this for a second. Strict scrutiny, if you remember, um, or if you didn't listen to it, you learned for the first time. We apply strict scrutiny to things like race and then also fundamental rights. And so, fundamental rights are rights that are explicit or implicit in the Constitution. And the interesting thing is that we actually have a strict scrutiny case that is in, I believe it went to the Michigan Court of Claims the last couple of days, and the judge just ruled on it. And it was about the governor's stay-at-home order, and most specifically that second extension of it that said you couldn't travel between your own two residences, and you couldn't do outside lawn care, and you couldn't go on your boat, and whatever, you couldn't go golfing and all this other stuff that you couldn't do anyway because it was snowing. But so five businesses got together and sued the governor over that executive order, and strict scrutiny was applied because the argument on behalf of the business owners was that they were saying their fundamental constitutional rights were being violated. And the interesting thing is that the judge said, no, they're not. And if you'll know, so there's a lot of politics at play right now with this whole, global pandemic. And it seems that there's a lot of partisan issues. And of course, we know that the governor is a Democrat. The protesters have largely been Republican. And I feel pretty confident saying that because they're, walking around with their Trump signs and their, Make America Great Again hats and that sort of thing, which of course would imply they're Republican. Well, the judge that handed the ruling down in this case in favor of the governor that said that, in fact, governors do have pretty wide emergency powers in instances like this, was appointed by Governor John Engler, who was a pretty staunch, for the time, Republican. He was governor. Well, let's see, I met him when I was in college. I graduated college in 2000. So he was the governor for the 8 years before Governor Granholm. So, like, right now we're in Whitmer, and then before that we had 8 years of Snyder. Before that we had 8 years, I think 8 years of Granholm, and then we had Engler. So, anyway, I love it when things I'm talking about actually come up in real life. So there you go, strict scrutiny in the courts right this very second. All right. Now we're looking at the quest for equality. As we know, the Declaration of Independence says we hold these truths to be self-evident that all men are created equal. And we all know from our study of history and of specifically, the history of the United States and essentially the history of the entire world, that that's just simply not true. Even like take even the fact that like women aren't included in there, but you're like, well, they said all men. So, okay, fine, like take that out. But all men, even at that time, they didn't actually believe that they were created equal. If they did, we wouldn't have had slavery. Um, we wouldn't have had, systemic racism for a couple hundred years. We wouldn't have, harsh policies on, immigrants and refugees, outside of the fact that, like, I get it, that people should be law abiding, right? And you should cross a border of a country legally and do so in legal channels. And I actually completely agree with that. Um, but this idea of, like, people being lesser because of their race, because of their gender, because of their country of national origin, because of their religion, because of their sexual orientation. I mean, it does play out in history that, when we talked about equality, what they really meant was, like, white male landowners, right? So I hate to talk that way about our founding fathers because I have a great deal of reverence for them. But when they talk about equality, it's not the way we talk about it today. So this idea of the quest for equality means that different groups of people, women, African Americans, etc., over the course of our history have had to fight for this, what anybody would say is a fundamental human right, is to be considered equal to another group of people, or just everybody equal in the eyes of human race. All right. First, we'll talk about gender equality. The women's movement actually began in, like, the mid 1800s. They tried to get the right to vote at that point, and they were actually granted it in some states. But their efforts, of course, if you look and you see 1848, well, what happened, about 12 years after that, or 13 years after that, that would be the Civil War. And so, their quest for gender equality sort of got pushed to the side because obviously the Civil War was a lot more major issue at that point, right? So splitting our country in half. Also, like, along this ideological line of slavery, right? So women kind of said, you know what, we'll put our own needs on the back burner for a while, and we'll help with this cause of getting rid of slavery. Of course, not all women, but the ones who were actively involved in the women's movement. And really, when you see that, you're thinking about any kind of progressive thought process has tended to come from your urban centers, right? So that women's movement, launched more with those who were, educated and living in urban centers rather than, like, agricultural and that sort of thing. All right, so women's suffrage, okay. Remember that suffrage means the right to vote. And we know that because we've talked about the, quote, suffrage amendment. They were kind of hoping that they would be given the right to vote in the 15th Amendment when African American males were. But again, remember, the 15th Amendment just said all male citizens over the age of 21. And the women are like, really? But why not us too? So states started more so at that point giving the right to vote to women. But again, you can't, like, it has to be granted federally, or else it doesn't matter on a federal level unless all women can vote. So in 1920, 100 years ago, which sounds like a long time, but it's really not, women were finally given the right to vote, as we know, in the 19th Amendment. All right. Then we have this idea of the Equal Rights Amendment. And so this was brought up in, like, started in the late 60s, but then really had a strong movement in the 70s and 80s. And the Equal Rights Amendment literally just states, like, women are equal to everybody else, right? Women are equal to men. So it was definitely this notion that we needed in the Constitution, that the law of our land states nowhere specifically that women have the same rights that men do. And so this push for the Equal Rights Amendment was a push to enshrine that in our nation's constitution. There's a really good documentary, not documentary, it's kind of like a from a true story type on Hulu right now, and it's called Mrs. America. And I haven't gotten all the way through it yet, but I've gotten through a couple episodes. It's actually quite fantastic. But and it's about this fight for and against the Equal Rights Amendment by women. So there is a ton of women who are for it. There's also a ton of women who are against it, which you can't even like really fathom right now. But if you think about, the 60s and the 70s, and even the very early 80s, women's roles in society looked a lot different than they do today. There was a lot of, still, especially in the 60s and early 70s, most women stayed at home. They didn't work outside the home. And there was a lot of like, still this like leftover, like leave it to beaver mentality of like, okay, the husband goes off to work and the woman takes care of the children and she cleans the house and she does the laundry and she has a nice hot dinner waiting for her husband when he comes home. And a lot of women at that time were quite comfortable with that role. And so to give the ERA, like one of the concerns there was like, well, if it says that women are equal to men, are you also going to put women, like are women able to be drafted now into combat roles in the military? And, obviously now we have a lot of women in the military and we have women in combat, but at that time that didn't happen. And because the draft was around in that time and we had the Vietnam conflict happening, there was a very real fear for a lot of women. So anyway, so there's a huge push either way for this and a lot of money and a lot of power behind both sides of it. So it almost passed. It still has not. And we talked about this in class. Virginia actually in January of 2020 became the 38th state to ratify. So remember this process of constitutional amendments, right? So Congress has to propose with 2/3 of both houses, both chambers of Congress, to propose amendment and to ratify it. 3/4 of states, so 38 states, have to say, yep, that sounds good. Let's put that in the Constitution. So Virginia was a 38th state in January. And everyone's like, yay, the Equal Rights Amendment passed. And then all these states are like, no, because there's an expiration date on it. Most amendments that are proposed have expiration dates. And they have to be ratified by. And that one did. And so it was not anywhere near, 2020 when the expiration date was. And so the argument is, well, no, we'd actually have to put this back to states again, because what if some states now who voted for it before in this original version have now decided they don't want to anymore? The only argument really that you'll hear against it today is that it's unnecessary. In that, when we talk about in the Constitution, when we talk about citizens, the rights of citizens in the 14th Amendment, that citizens include women at this point. And so the ERA, according to a lot of people, is not necessary because it grants those rights to all people. And so why are you then like singling out women and saying, well, then this is the way it is. And then also the Civil Rights Act of 1964 grants rights specifically to women in terms of like anti-discriminatory laws. All right, so the Civil Rights Act, of 1964 that we will talk about at length in a couple of slides, that's why I don't have it on here, that did a ton for gender equality in terms of anti-discrimination against women. But then we have Title IX, and I'm certain, especially those of you who play sports have probably heard of Title IX, and it's Title IX of the Education Amendments of 1972. Who was president in 1972? That would be Nixon, right? So he signed a series of executive orders, and it wasn't like amending the Civil Rights Act through Congress, but it was trying to amend the Civil Rights Act through executive orders, and it was more of a clarification. And if the clarification was in Title IX that if you received federal funds, then you couldn't discriminate against women in the employment realm. And so then, like, that was Johnson's executive order, President Johnson. And then Congress went and did develop these education amendments. And what happened, so they were signed into law with Title IX. I'm sorry, I didn't really explain this very well. By Nixon in 1972. So originally by Johnson, the executive orders were put together, and then Congress passed sort of the same type of legislation that was in the executive orders, and Nixon signed it. And Title IX, the reason why you know that, if you play sports, is because one of the things that it covers is, opportunities in education must be the same for girls and boys. And if we're going to err on one side, we're going to offer more opportunities to girls than we are to boys. So like if you add in, like if we were to add boys lacrosse at Marysville High School, okay, in order to do that, you would have to add a girls sport as well. And then you also have to offer the opportunity for girls to play sports that are not offered in their specific gender or their specific sex. So like you have to offer the opportunity for, girls to play football if they want. However, you do not have to offer the opportunity for boys to play volleyball. So it is like, you could argue it's discriminating against guys. But the entire point of it is to, again, like level the playing field for women. Okay. Racial equality, as we know, has a very long and brutal history. So the first step toward racial equality, specifically for African Americans, were what we call the Civil War amendments, as we know. So the 13th, 14th, 15th. 13 abolished slavery throughout the United States. Of course, it was really only in the South at that point, as we know. We fought a war over it. And, that's like the bare minimum that you could do to try to give somebody the start of equal footing, is make it so that they at least could not be like owned by another person. And it's hard. Like, when you think about this and you think about that this was not that long ago, I mean, it's heartbreaking that we actually had the mentality that, an entire race of people were so much less than that we could actually own them as property. And it's disgusting, and it drives me absolutely like insane, and I like hate our country because of it. But I love our country, as you know, but like that is just such a horrible mark on our history, and I wish that it had not happened. So the 14th Amendment, that's one of the largest amendments. You could argue probably the most important amendment outside of some of the ones in the Bill of Rights. But the Due Process and Equal Protection Clause that applies to the states, and it defines what a citizen is. The Due Process and Equal Protection Clause of the 14th Amendment, as we know, have been used to incorporate the Bill of Rights into the states. And then the Equal Protection Clause specifically has been used to create and defend civil rights legislation over the course of our history. And then the 15th Amendment is all citizens have the right to vote, but at that time, of course, citizens meant male. So they'd be male citizens. And that was over 21 or 21 and over. There were efforts to try and pass civil rights laws in the 1860s and 70s, and they were all struck down by the Supreme Court. Plessy versus Ferguson, which is not one of your required cases, but you should just know it because it's such an important case in our history, and it stood as precedent for a very long time. But it upheld this idea that segregation was okay, and the justification of it was as long as, like, you can have separate facilities as long as they're equal, right? So the separate but equal. Plessy versus Ferguson specifically had to do with a gentleman who was 7/8 Caucasian and 1/8 African American. And he went and sat in a whites only train car, and they kicked him out. And he said, "That's ridiculous. I don't want to go sit in the other one." And they said, "Well, you have to." And so he ended up suing and losing, because they said, "No, like, we don't need to have you sit there. There's a perfectly fine train car that's made for African Americans," or, whatever. I'm sure they weren't called that at the time, because they would call them something else. But there's a different car for African Americans, and it's just fine. And so, you can be separate as long as we're offering, equal conditions. And equal was never equal. I think what the court decided was equal was like, we're offering it and it has some chairs in it, right? So, and as we know, with education, this separate but equal stood until Brown versus Board of Education, because the deciding factor was the fact that separate is inherently unequal. Like, if you have to separate people, you don't see them as equal to each other. But anyway, so there is no real progress, like statutory progress, like legal progress, legislation, court cases, what have you, until the 50s and 60s. People were starting to make progress, right? So you would see, a lot of civil rights demonstrations and that sort of thing. But you would not see any meaningful legislation until the 60s, any meaningful cases until 1954. All right, let's talk about voting. So racial equality in terms of voting. So the states regulate elections and voting qualifications. Voting qualifications outside like age and citizenship and that sort of thing. So even though all adult male citizens were given the right to vote with the 15th Amendment, it was still not easy for African Americans to vote. The Supreme Court actually handed down a ruling in the 1880s. I don't remember the case, and I'm sorry for that, but that said that that election workers or police or whomever, local law enforcement, had no duty to protect Black voters from white mobs at the polls. So they're like, sorry, if you want to go vote, like, you have to take the good with the bad, and if you're going to get taken by an angry mob, like, that's not really our fault. So that was legit the Supreme Court position of the 1880s. And then specifically in the South, and I'm not saying the North was without fault, okay, certainly, but specifically in the South, there was a lot of obstacles that were put in place to keep Black people from voting. I believe, in fact, I know that we took that Louisiana literacy test. I usually do it in the in Unit 4 when we talk about like redistricting and gerrymandering and all that kind of stuff. But like, remember how ridiculous that was, right? I'm like, you have 10 minutes to do this, and you have to get every single one of them right, or else you can't vote. And it was given to anybody who couldn't prove a 5th grade education. Well, most Black people were not, unfortunately, given education opportunities like that. And so, that's just one of the obstacles that were given there. There's also white primaries. There was grandfather clauses. There were poll taxes, all sorts of things that were deliberately designed to keep African Americans away from their fundamental right to vote. Oh, here we go. Disenfranchising Black voters. So literacy tests, like I said before, for whites, they were either easy or non-existent. For Blacks, they were ridiculously difficult. There were white primaries, and this was done by the Democratic Party in the South. And remember, that was like the Democratic Party and the Republican Party have like fundamentally shifted. right? So like the Democratic Party in the South during this time would really be the Republican Party now. And I'm not saying that the Republican Party now is, continuing to disenfranchise Black voters on a large scale, but I'm just saying that like the people who would belong to the Democratic Party during this time of, literacy tests and white primaries and everything else would be Republicans now. There's a realigning election that took place in there that moved, that again shifted the parties. So only whites, in white primaries, only whites could vote in the Democratic primary. And so usually in the South at that time, like the South was solid for Democrats as it is solid for Republicans now. And so there was no Republican contenders in most contests that would, haven't like do any meaningful damage to a Democrat. So a Democrat would win, whatever it is every time, whether it's a mayoral election or a congressional seat or, even like presidential primaries and that kind of stuff. So if only whites could vote in the Democratic primary, and there like was never really a decent challenge from a Republican, you're essentially you're not allowing blacks to vote in the general election. It's like in the 10th district, right? The district that we're in, which is a super safe Republican seat. It would be like saying, I'm sorry, you group of people can't vote in the Republican primary. Well, the Republican's going to win the 10th district every single time. Paul Mitchell, who is not a popular congressman at all, won with like 66% of the vote in 2018 in the midterm election. And that's typical in this area. And so to say to somebody you can't vote in the Republican primary, like you're basically taking their right to vote away because the person who's going to come out of that election is the Republican. All right, then we have racial gerrymandering. And that was drawing districts specifically to ensure that black voters would remain the minority in each district. We looked at a case, Shaw versus Reno, about racial gerrymandering, and it was actually districts that were being drawn to ensure that blacks had the majority in districts. They're called majority and minority districts. And those are actually legal, but in Shaw versus Reno, the court decided that they went a little bit too far. And so they drew ridiculous districts in order to have a majority minority district. And like, so yeah, for sure, race can be a factor in that, but it can't be like, egregious. All right, poll taxes were just, you have to pay in order to vote, which again disenfranchised black voters because at that time they were typically less well off than white voters. Of course, that was outlawed by the 24th Amendment. And then this idea of grandfather clauses. And the grandfather clause, like we talk about like, oh, you're being grandfathered in, right? That means like something that is now applying to people is not going to apply to you because like you were already there before. So grandfather clause in terms of voting meant that there is, meant that there is you were exempt from a literacy test and poll taxes if you could prove that your ancestor, your grandfather, but if your ancestor was able to vote in 1866. Well, the 15th Amendment that gave African Americans the right to vote was not passed until 1870. That's when it was ratified. So anybody who is black in the South, their grandfather could not vote in 1866 because they didn't have the right to. Okay, now if you're in the North, different story, but the North isn't doing grandfather clauses. All right. Jim Crow laws, I'm sure you guys talked about this in your study of U.S. history. Jim Crow laws were state regulations in the South that required and encouraged, so encouraged and required, public facilities to be segregated by race. And there is a couple different court cases that enforced these Jim Crow laws. The civil rights cases of 1883, which were like a whole bunch of cases that were sort of combined and ruled on together, they ended up, so Congress had passed a law that made it a federal offense to deny any accommodations because of race. Okay, so it was kind of the start of the Civil Rights Act of 1964, but in 1883. And the Supreme Court overturned that law, declared it unconstitutional, stated it was an overreach of congressional power. So the courts at that time said, no, sorry, Congress, you cannot pass a law that says that people have to provide accommodations to people, even if, they're racist. And then Plessy, which we talked about already in 1896, established that separate but equal precedent that would live until 1954. All right, turning points in racial equality. So the 14th Amendment, once people kind of started really using it in earnest, and sort of the tide of the country shifted a little bit, that Equal Protection Clause in the 14th Amendment allowed people to make great gains. So first things first, we have the Brown ruling, which we'll go through in a second, because that is a required case. That was in 1954. And you could argue that is the first major, victory for civil rights in terms of African Americans. It didn't change much at the time, but the ruling itself was very, very, very fundamental. Civil Rights Act, of 1957, and I put ish because it didn't do a lot. Really, the Civil Rights Act of 1964, that's the huge one, and the Voting Rights Act of 1965. The Civil Rights Act of 1964 and the Voting Rights Act will go through in earnest here. The 24th Amendment, like we said, outlawed poll taxes. You saw some Supreme Court decisions regarding apportionment, and they weren't at first, they were not about race, but it allowed for that to be a consideration. So Baker versus Carr, that's the Baker is known for you guys anyway as the one person, one vote case. So districts have to be drawn so that they're as equal in population as possible, so that people's votes are counting kind of the same way. Although remember that Baker didn't actually do that. Baker just said, yep, it's a justiciable issue, and then Reynolds actually did that. But the College Board, in their mind, Baker is one person, one vote. 1948. I don't know why this isn't up a little bit further. They outlawed restrictive covenants. Restrictive covenants means that so if you have the deed to your house, so you own your house and you have the deed, and this was done in the town I grew up in, which is disgusting, but there was a lot of people that would write in their deeds that their house could never be sold to a Black person. And it was a way of keeping cities and suburbs mostly white, and keeping African Americans out of the suburbs and keeping them in their urban communities. So in 1948, that was outlawed. It still happened, though, just so you know. And then 1968, the Fair Housing Act happened. So a lot of times African Americans were being denied housing because of their race. So 1968, that Fair Housing Act made it so they could not be denied a loan or a place to live, like a rental or whatever, based on their race. All right. 50s and 60s, again, we have this emerging social conscience, like I said. So laws usually follow public conscience. There's a lot of laws that aren't legislation isn't usually a leader. The public is usually the leader, and then legislation follows, or court cases follow. And that was certainly the case with racial equality. It's also the case, and again, we talked about this case a little bit, but Overtrell versus Hodges, the one that outlawed laws restricting same-sex marriage. So it made same-sex marriage federally legal. And there were several cases before that went up through the Supreme Court that didn't do that. And so, you have to look at like where the tide has turned. Okay. So the tide had finally turned by 2015 where, the court's like, most people are at this place. Most people are like, yeah, that's cool. Who cares? But you look about like the ones that were like the Defense of Marriage Act and that kind of thing that were when the Defense of Marriage Act was upheld a few years earlier, the court was not fundamentally different, but the public was. And so a lot of times the public gets on board with things and then legislation follows. So anyway, there was a Southern filibuster in 1957. And again, remember, we talked about that specific filibuster. Excuse me, I'm yawning. And that was Strom Thurmond. It was the longest filibuster ever. And it was against the Civil Rights Act of 1957, which had to do some with voter discrimination. And then again, the public was starting to pay attention a little bit more. And also African Americans were starting to act, right? So this is the time in which you see, these peaceful protests and civil disobedience and that sort of thing. Rosa Parks on the bus and Selma and, the March on Washington and all of these things. And so like those are covered by the media. And so what's also seen, is not just the people, peaceably assembling, but it's also, you see pictures of the police like beating these people and like, putting like fire hoses at them. And it's like just horrible to watch. And so people are finding like, my God, like what is wrong with these people? Like, why are we doing this? So people sort of start to look inward and really, question their own morality and then really make a push to do something about this. Because at that time, you needed, like Black people needed white people to make the laws because they were the ones in Congress. And so, the people who are responsible for this legislation also had to see it. And they see it when the public sees it and when the public pushes them. And they call up their congressman and say, pass this stupid law. Like, this is ridiculous. So that has to happen a lot of times, like in terms of, fundamental legislation being passed, like, what we call punctuating policy, whether it's civil rights back then or healthcare now, it's often pushed by the public. Of course, there's still resistance in the South, as we know. At that point, their facilities still inherently unequal. They just chose not to follow laws that were created. And, the public there was not necessarily changing their mind. I mean, but like, think about that. And trust me, I'm 100% not justifying, racism, because that's ridiculous and I never would. But, if Congress passes a law that you fundamentally disagree with, your opinion is not going to change because it's law. Now, you should probably still follow the law, but your ideas of right and wrong don't necessarily ebb and flow with legislation. And that's why it's hard, because you can't push opinions on people. You can push laws on people. You can't push opinions on people. So that takes a little bit longer. All right, here we finally are at it. So the Civil Rights Act of 1964. This is the act that forbade discrimination on the basis of race, color, religion, sex, or nationality. Title II focus on what's called places of public accommodation. So any lodging establishment, hotel, motel, whatever, that's larger than 5 rooms. any restaurants or gas station, any place of entertainment, so movies, movie theaters, regular theaters, sporting events, etc. You could not deny service to somebody based on race, color, religion, sex, nationality in these places. So if you own a restaurant, you can't refuse somebody's service because they're Black or they're a woman or they're from a different country or whatever. The Civil Rights Act was solidified in it was called the Heart of Atlanta Motel case, this Supreme Court case, in which the owner of the Heart of Atlanta Motel had denied accommodation to an African American, and then the court said, yeah, no, you can't do that because it's in the Civil Rights Act. So a lot of times too, Congress can pass all the legislation they want, but and it's law until it's fought in the court system, and then the court gets to say yes, constitutional, no, not constitutional. And so for the courts to have upheld the Heart of Atlanta case was a huge deal, or upheld the Civil Rights Act in the Heart of Atlanta case. Title VII is with respect to employment. So if you have 15 plus employees, you cannot discriminate. Why you can under 15, I don't know. There are exceptions, religious institutions, and actual qualifications. And if you listened to the last lecture on civil rights, at the beginning part of it, we talked about this actual qualifications thing with the Hooters case. It never went up to the Supreme Court, but it was in district court in Illinois, where 7 males sued because they were denied waitressing jobs at Hooters. And Hooters is like, yeah, we don't hire men for waitressing jobs. And they're like, I know, and that's sexist. And that goes against the Civil Rights Act of 1964. And the courts actually ruled in favor of Hooters and said, no, this would fall under the BFOQ, which is bona fide occupational qualifications, which means that you had to be a woman and a woman who looked a certain way in order to be a waitress at Hooters. And so the courts upheld that. Title VII also created the EEOC, which is the Equal Employment Opportunity Commission. So that is if you believe that you have been denied a job based on actual qualifications, or based on your color, your national origin, your religion, your sex, whatever, but that there are but you meet the bona fide occupational qualifications, then you can sue. And a lot of times you would do through the EEOC. Again, Civil Rights Act of 64 was not passed without extensive debate, and it did not end the civil rights struggle as we know. I mean, we're still living in it today. We still don't have a nationwide idea of equality. Voting Rights Act of 1965, this one was huge. So the Supreme Court was ruling on voting, and they could rule all they want, right? But what you have to remember is Supreme Court cases do not establish law. So they say this law is unconstitutional or this one's upheld, but they themselves do not make law. So they needed Congress. They needed Congress to once and for all say, you need to let people vote. This is a fundamental right, is your right to vote. And so we are going to put legislation together that reminds you that you need to let people vote. So the Voting Rights Act of 1965, it prohibited standards that result in denying any citizen's right to vote or dilute the power of any group. So in the Voting Rights Act of 1965, literacy tests were outlawed. Poll taxes were not, because there was 24th Amendment, but racial gerrymandering was outlawed. And again, I referenced this on the last slide. Later, they allowed majority minority districts to the point where it was proportional to voting age population. So you could create districts that were majority minority, meaning the majority of people in the district were minorities whose power to vote had been historically disenfranchised. But you had to only do it to the point that the percentages were equal, that was the problem that was in Shaw. More recent voting rights that are not necessarily race-based, but allow people to vote easier. The National Voter Registration Act of 1993, we know that as the Motor Voter Bill. It allowed voter registration to take place at the DMV, which is the Department of Motor Vehicles, which is what it is in most states. In Michigan, it's the Secretary of State. And then, of course, the goal is to ease the registration process and register more people to vote. In Michigan, we now have like same day voter registration. And when we did our voter registration drive in the fall, like if you recall, we're literally able to like fill out a form that had your social security number and your address and your name or whatever. And I just dropped it off at the city clerk. Like, you don't have to register in person anymore. Which, some people say is a great thing and some people say is a bad thing, because, you have these claims of voter fraud and they're like, well, how do you know if like you've never like stood in front of anybody and said, I am who I am. And, that's a legitimate argument, certainly, but you can also argue that there is no widespread voter fraud and we've done it this way. So, the interesting thing now that we talk about because of coronavirus is the vote by mail, and the thought that in November, the entire election will take place voting by mail, which is, I don't know how I feel about that. I mean, I think that it is a good thing to allow. Like, I think that we should allow it. I worry about, do all the votes get counted? Do you know what I mean? Like, if I mail them in, like, they're not just sitting like a bunch of votes in a warehouse somewhere, right? So that's the only thing I worry about with voter by mail. I don't worry about voter fraud with that. I worry about like counting all the votes. Issues today, we have voter ID laws, and those are state by state. The Supreme Court is staying a little bit far away from this, and they kind of refuse to rule in any measurable way on a national level as to whether or not voter ID laws are constitutional. We actually have you don't have to show your ID in Michigan to vote. The people who work the polls in Marysville don't actually know that. I mean, there's a spot on your little voting thing where you can, like, if you don't have an ID, you can sign an affidavit that says it. But literally every time you walk up there, they're like, where's your ID? And so I always want to like sort of challenge them and be like, I don't have to show my ID to vote, and see if they actually know. But it's always like 7 o'clock in the morning and I'm trying to get to school, so I haven't done it yet. All right. Education rights with respect to race, again, separate but equal, was not only the norm, it was the precedent. The NAACP, which is the organization that helps African Americans, so National Association, I know this is colored people, and it's just one of those things that I'm like, why don't they change it? But it's because the NAACP is so well known. But they had what's called their legal defense fund. And the legal defense fund of the NAACP helped a lot during this time of civil rights cases. And so they would take on these cases that they thought were, or these laws that they thought were racist and needed to change. And they would do it like on behalf of people who would ordinarily not be able to, bring a case to the court system. So the legal defense fund was huge. And they took the position that separate is inherently unequal. Because again, if you are taking two groups of people and you are separating them, why? Right? Like, what is the point of that? Like, of course it's unequal. If everybody's equal to each other, why isn't everybody in the same classroom, right? So there's two cases for this. There's Brown 1 and Brown 2. Brown 1 is the famous one. That's the one you need to know. Here we go, required case. Brown versus Board of Education of Topeka, Kansas, 1954. So this is a consolidation of cases that arise in several different areas. And, African American students were being denied admittance to public schools, like their neighborhood public schools, they could not go to because there were laws in those specific states and others that allowed public education to be segregated by race. And so these kids were going to schools that were super far away and not their neighborhood schools because they weren't allowed to be there just because they were Black. And so the argument is that segregation in this way violates the Equal Protection Clause of the 14th Amendment. Like, these kids are not given equal protection of the law because they're not allowed to attend public school. Okay, and we saw before, like, public school or education is not a fundamental right. It's not enshrined in the Constitution, but it certainly is a right, you know? And so they were arguing that taking the right away from a child to attend their own neighborhood public school was unconstitutional. They were arguing that huge precedent of Plessy, which had upheld since 1896, that racially segregated public facilities were legal so long as the facilities for Blacks and whites were equal. And then the constitutional question in the case is, does the segregation of public education based solely on race violate the Equal Protection Clause of the 14th Amendment? And they could have ruled on this before, but they wanted to make sure that by the time they did, because it was going to be such a landmark case. It's like sometimes you just know you're ruling on something that's going to like fundamentally change society. They wanted to wait until they had a unanimous court. And so the holding was unanimous for Brown. And they said, separate but equal education facilities for racial minorities is inherently unequal. So yes, it violated the Equal Protection Clause of the 14th Amendment, and they ordered schools desegregated throughout the country with, quote, all deliberate speed. And that's the focus of Brown too, because it was not done with all deliberate speed. And I'm sure in your study of American history, you've seen the pictures of, there's a very, very famous picture, and I thought I had it in this, but I guess I don't, of a young Black girl going to school for the first time and like crossing this, it almost looks like a picket line, right? Like crossing over this group of white people who are screaming at her and throwing things. And, it's just so sad to look at. And again, like, think that, slavery was a couple hundred years ago. This was in the 1950s. Like, my mother was in elementary school in the 1950s, so like, that's not that old, and that's how we treated people. So anyway, the significance, of course, beside the fact that it desegregated schools, which is a very large significance, but beyond that, it was really the first major victory for African Americans in terms of civil rights. Our huge thing was that it overturned the doctrine of separate but equal. And then it became a turning point for civil rights. So like we finally won this case, and it emboldened people who are fighting for civil rights to keep going. Again, as I said, all deliberate speed was not followed. So because desegregation of schools by law does not necessarily lend itself to immediate integration of schools. So Congress amended Title VI of the Civil Rights Act of 1964, and they said, you know what? Fine. You don't want to do this? We're going to make you. We're going to do, like fiscal federalism, right? So we're going to take money from you, and we'll withdraw your entire federal funding if you show signs of discrimination. But the thing is that people still lived in different neighborhoods. Okay, I grew up in Grosse Pointe, as I've said several times. Grosse Pointe is right next to Detroit. Like, you cross Mack and you're in Detroit, or on the other side of it, you cross Alter and you're in Detroit. Detroit was very much African American, and Grosse Pointe was very much white. And so when you're talking about Brown and sending kids to their neighborhood schools, the neighborhood schools in Detroit would be Detroit, the neighborhood schools in Grosse Pointe would be Grosse Pointe. And so in order to integrate schools that were this idea of de facto segregation, some federal courts ordered mandated busing. And you will probably hear about this come up again in the presidential election. Kamala Harris brought this up as one of the reasons that Joe Biden would be unfit to be president, because he was in favor of busing in the, when was that? I can't remember when exactly it was, but she had a huge issue with him with his stance on busing. And of course he's Joe Biden. And so he sort of fumbled his way through a non-response. But the idea of busing ended up being very, very, very unpopular. And it was unpopular with both the people who were being bused from a historically Black school to a historically white school, and those who are being bused from a historically white school to a historically Black school. But the interesting thing is that all busing did, and the unpopularity of it, all it did was prove that idea that separate but equal was not equal. Because if it was, then nobody's going to, excuse my language, but nobody's going to bitch about going to a different school if the facilities are in fact equal. But they weren't. You take a kid from Grosse Pointe, who at that time was funded mostly by, local property taxes. I mean, they spent a ton of money on their kids every year. You take them and you bus them to Detroit, where, the buildings are falling down and there's no running water and this kind of stuff. And of course people are going to be upset. So why did I leave my place? And now I'm going over to this one. Well, again, thank you for proving our point that facilities were not equal. So thanks. You just proved that this ruling was needed. So now how do we fix it? And we are still trying to figure out how to fix that today. There is still so much inequality in education. It is absolutely insane. And it is drawn on urban and suburban lines, honestly. So sorry, I got way off track there. But so with this busing situation and any situation that kind of forced integration, the Supreme Court tended to allow it if the law was trying to remedy what's called de jure segregation. So by law, not de jure like the soup of the day, okay, but de jure jury, juris doctorate is a JD, that's a lawyer, right? So if it was de jure segregation, so meaning there was a law that said that we are segregating people, now we can do things to overturn that law. They tended to not allow federal judges to order things to overcome what's called de facto segregation. And de facto means just because that's the way it was. And the Grosse Pointe in Detroit example is a really good example of de facto segregation, because it's simply where people lived. Now, you could go back further and argue the reason why it was where people lived is because Grosse Pointe had restrictive covenants that they shouldn't have had. And so they actively kept African Americans out of their community. But since restrictive covenants were technically illegal by that time, you could not argue that. But I mean, let's get real. That's why it was the way it was, right? Even by the time I went to, I graduated high school in 1996, and out of a class of 320, we had 2 Black people. That's it. I think it's a little more, I think it's more now, but still not, it's certainly not in any meaningful way. I mean, it might be 10%, right? So it's still it looks like de facto segregation, but it's because of original de jure segregation. All right. 1990s, the Supreme Court kind of said, you know what, federal government's sort of done with this idea of education. That should be a state issue. So they restored most control of the school system to the states, which is good and bad. But if you think about racial segregation, it was not a good thing in some states. And then, like I said, a lot of places, the high school that you attend is still essentially segregated, but it's not because of law. It's because that's where people are living. Okay, last thing, I think. Yes, all right, affirmative action. So, affirmative action is defined as remedial action designed to overcome effects of discrimination against minorities and women. So like, hey, thanks, sorry that we've discriminated against you for so long. We're going to have some laws that we're going to put in place that will not only make things equal, but hopefully like bump you up a little bit, okay? A lot of opponents of affirmative action will call it reverse discrimination. And this, you'll usually hear white males say this because they're like, it's not fair because like I'm trying to get into college and I can't get into college because they have to leave so many spots open for women and minorities and that's not fair. It's like, well, but like for so long, they haven't been able to get into school. So I'm sorry that you're living through the time where it's going to be harder for you, but imagine what it's like to be them, right? So there's several cases, and again, none of these are landmarks, which again, I'm surprised that one of them's not, but University of California versus Bakke, which was in 1978. And there was a question of, it was this idea of the quota system, okay? So it said that, like, if there were, in the University of California, if there were 100 spots open for admission, that 16 of them were, quote, reserved for minorities. So you better be one of the top 84, white males, or else you're not getting in. And they would take 16 of, whether it was African Americans or women or, other historically disenfranchised groups of people, and they would reserve spots for them. And the argument is to give spots to people just to give spots to people. Like, what if they're legitimately not as qualified as some other applicants? So like, if I'm a white male, in order to get in, I have to have a 4.0, but in like some of the quota spots, the highest woman they can find has a 3.7, and that's not fair. Like, so that was the argument. Okay. So they did say, the court ruled that they can use race as one factor in admission among a lot of other factors. And then they outlawed that quota system. They said that is too stringent. You can't do that. And then we had two cases that were actually with respect to University of Michigan. So we had Gratz versus Bollinger and Grutter versus Bollinger, which both happened in 2003. One was undergraduate, one was law school. So the undergraduate issue was that that U of M had a 150-point scale. Okay, so they used 100 for test scores and grades, and then 40 were for other factors. So were you a legacy? Were you from a rural area? Were you economically disadvantaged? Were you an underrepresented minority, et cetera? So like, we'll give you kind of like more points for being one of those things than for being this like super privileged white male from Grosse Pointe. And now that I'm looking at that, that's 140. So I'm not sure where the other 10 came from, but it doesn't matter. Supreme Court ruled that looked a little bit too much like the quota system. Like, that was too mechanical, and like, you have to take more of a holistic approach to it and just like look at an entire person rather than give away points based on the fact that you're economically disadvantaged or from an urban area or a rural area or what have you. Grutter, for U of M Law School, the Supreme Court kind of went the opposite way, and they upheld their admissions requirements there because it was used, like I said, in a more holistic approach. So they're looking at an entire applicant rather than assigning points based on certain attributes that applicant has that have nothing to do with grades or test scores or anything like that. And then the most recent one, there was a Harvard case that didn't go to the Supreme Court. I'm pretty sure it will if the Supreme Court takes it. I'm sure they'll appeal it. So Harvard won at the federal district court level. but I would expect this will continue to go up the chain in the court system. So this was an interesting one. This was just in 2018. So there were Asian applicants that sued Harvard. And because Harvard also, like any other school, is interested in having, a balance of people, a balance of races, a balance of genders, a balance of religions, a balance of backgrounds, a balance of everything. I mean, that's what colleges look for, right? Like that's what, they don't want this homogeny. They want like a heterogeneous applicant pool and, student body and what have you. And so Asian applicants they sued Harvard on the suggestion that Harvard's desire for racial balance made it harder for them to get in. And so like Asian students who are applying were saying, well, this isn't fair because like we are actually the most qualified in terms of, test scores and grades and, overall intellect and that kind of thing. But like you also like you don't want an entire school of Asian people. And so you're like letting these random white people in and these black people and these, whatever, in order to balance this out. And that's not fair. And so like Asians are kind of taking this idea of, like I said up here, opponents call it reverse discrimination. They're saying because you are allowing these, you're making it so that other people have to get in, like we're not getting in and we're the most qualified. It's an interesting argument because it's the first time that I know of that a group other than white people are arguing like this quote reverse discrimination argument. So that will be an interesting one to follow. All right, that was like the longest lecture ever. I really apologize. But guess what? We're done with civil rights and we are done with the class. Oh my gosh. That's crazy. I'm just so sad that we didn't get to do this as a group because I love the discussions that come out of both civil liberties and civil rights. They're just so good. So anyway, that's it. We're done. I hope you enjoyed. Have a good day.